Hey everyone, Attorney Davis Yance here. Listen, I wanted to do a quick video about the Supreme Court's decision from last week. Now, it was a 4-4 decision that essentially amounted to one sentence, and you may have missed it going into the holiday weekend, but it is really a significant decision and has a significant impact on religious freedom. So what we want to do is I'm going to start with a short video. You're going to see the Attorney General of Oklahoma, then the governor of Oklahoma and the superintendent of schools of Oklahoma giving their perspective on this, and then we'll have some reaction. So here we go. Again, we start with the Attorney General of the state of Oklahoma.
Oklahoma wins. I'm so pleased. To the extent other elected officials have rhetoric to the contrary, you can ignore them. They don't understand the law, nor do they appreciate the sanctity of religious liberty.
Attorney General Gentner Drummond celebrated Thursday's 4-4 tie in the U.S. Supreme Court, dooming efforts to open the nation's first publicly funded religious school. Governor Kevin Stitt's office confirmed today they're looking for avenues to keep the dream of the school alive. State Superintendent Ryan Walters also talked options Thursday, including getting the issue back in front of the court.
We are actively pursuing what those courses of actions may be. Could be a reapplication by the school. Could be an application by another school.
Right now, the court is not hearing any other similar challenges from other states. And in the St. Isidore ruling, the court pointed to Oklahoma's constitution, barring public money from funding religious institutions. So another path supporters of the school look at is changing the Constitution.
We're also looking at a potential amendment to the state constitution to help clear up.
All right, I'm going to stop it there, and I just want to break down a couple of things by way of background, then we'll get more into the specifics of the ruling. So this is a really interesting case. What's going on here is there is a Catholic charter school that applied to the State Board of Education to allow them not only to function as a charter school, but to receive state funding for this charter school. Now, keep in mind, not a single student would have to go to this charter school, and Oklahoma has non-religious and other charter schools. So just keep that background in mind. So this Catholic organization applied for and was approved for starting a charter school. They met all of the requirements to be a charter school. So what happened here is the Attorney General, the elected Attorney General of Oklahoma, sued the state of Oklahoma's Board of Education that authorized this charter school. It went up to the Oklahoma State Supreme Court. The Oklahoma State Supreme Court ruled in favor of the Attorney General against the charter school, and it went up to the United States Supreme Court. And what happened at the United States Supreme Court was not a decision one way or the other. It was a literal 4-4 split. 4 justices voting with the Oklahoma State Supreme Court against this religious school, 4 voting for it to overturn the ruling that stopped this school from going into existence and receiving public funds. So what you have here is one justice, Justice Amy Coney Barrett, recusing herself from this case and not voting, which opened the door for a tie. When there's a tie on the Supreme Court, a couple of things happened. One, it's a non-precedential decision, so there is no written opinion. They do not reveal which justices voted for or against the decision, and they do not have to state why a particular justice has recused themselves from the decision. So I want to talk just kind of practical implications a little bit, functionally what happened here, and then some more significant things about religious freedom. So a couple of pieces on this just to understand. Again, a 4-4 decision. We don't know which justices voted which way. We can assume that Justice Roberts voted with the 4 more liberal justices, whereas Gorsuch probably joined Kavanaugh, Alito, and Thomas, and that's just based on their previous rulings. Particularly, Justice Kavanaugh has been very, very solid on these religious freedom issues. And I say these are religious freedom issues because that's really what this case is about, and we'll get into that. But the other practical piece of this is Justice Amy Coney Barrett. Now, we can only speculate as to exactly why she recused herself in this case. She does have some ties to individuals and organizations that were at least tangentially involved in allowing or starting this organization. She had some ties to it. She is a Catholic, and so there was things there, but there was no monetary gain for her. This is not a decision that she had any part of in a lower court or where her previous rulings as a judge would have impacted it. And keep in mind, that's typically what we see when a judge especially at the Supreme Court, recuses themselves because it creates this risk of a 4-4 tie. So it's very, very rare. Most recently, we've seen a justice like Alito who excused or recused himself from a decision because he had a very small amount of money, maybe about $15,000, invested in a stock or a fund, and that company was coming before the Supreme Court for a ruling that might potentially impact them. And I believe it was Justice Kavanaugh who recused himself from a case involving attorney Michael Avenatti. Now, attorney Michael Avenatti represented one of the individuals that accused Justice Kavanaugh of sexual impropriety during his confirmation hearings. And so Justice Kavanaugh felt he couldn't personally remove himself from that situation enough to give a fair ruling in the case. So those are a couple of examples. So that's what we see. Now let's talk about what's really going on behind the scenes and how we got to a 4-4 tie in the first place. And what we have to do is we have to look at some distinct rulings related to public schools, education, and public funds from the Supreme Court. Now, we know there is a long and sort of sad tradition of the United States Supreme Court failing to recognize that secular humanism, that atheistic secular humanism is a religion. And I will submit to you, there is no such thing as a secular school in our country. If you take any reference to religion, you take any reference to God out of the public schools, what you end up creating is a system that marginalizes religion, teaches children to marginalize religion, that there's something wrong with it, or that it's not allowed in public spaces. And instead you substitute that with atheistic secular humanism, Darwinian evolution. So I'll submit to you, there's no such thing as neutral ground. There's no such thing as a truly secular school. And once we recognize that, we can step back and understand the decision. So again, I will submit to you, there's a huge difference in this case between even the prayer in public school cases where there was this fear by the courts of some sort of coerced religious teaching or coerced religious participation. Very, very recently, there has been a string of cases, 3 in particular since 2017, where the Supreme Court has ruled in favor of allowing public funds to go to schools. There was a Missouri case where it was found to be unconstitutional and discriminatory not to allow a private religious school to apply for a state grant for playground equipment. There have been other cases in Montana and in Maine where essentially you're looking at scholarships or other types of funding that's neutral funding from the state or the federal government that goes to religious schools. And essentially religious schools were being discriminated against, whereas private schools that were supposedly secular, not specific to a particular religion, were allowed to receive that funding. So there's been this really consistent trend towards allowing religious schools to receive funds as appropriate from the Supreme Court. In this case, what you have is a charter school applying to become a licensed state charter school in Oklahoma that had a specific religious purpose and was a part of essentially the Catholic diocese promoting this. Now, what's interesting about this, and where I think the Supreme Court got it wrong, particularly whichever of the 4 justices voted the way they did in this case to affirm the lower court's decision, the issue is no one is forced to go to this school. This would be a charter school where participation and going to this school would be voluntary. So in many states like Oklahoma, children can go to a charter school. Parents can choose to send their kids to a charter school with a particular emphasis. It could be a training emphasis, a vocational emphasis. It could be a cyber emphasis, but they could do all of those things and they can make a choice. And that's where I think the Supreme Court got it wrong, at least those 4 justices. This organization should not be discriminated against. They should not be prohibited from having a valid school that meets all the state requirements simply because it's being put forward by a religious organization and simply because they have a particular religious goal in mind. And that should be the case where participation in this is voluntary and no one is being forced to go to the school. So hopefully there will be another challenge to this ruling from the Oklahoma State Supreme Court or a similar ruling from another state that will allow this to go forward and will allow us to have appropriate funding for these religious schools. And again, these religious schools should not be discriminated against simply because they're of a particular religious faith. And that's obviously important when we consider the fact that what we have as public schools in this country are essentially government schools that are designed to indoctrinate our children with whatever the state deems appropriate, including atheistic secular humanism. And we have seen the chaos that's created. So hopefully this helps answer your questions about this case and what happened. Thanks for checking us out. Take care.